justice laws must be toughened after a Supreme Court judge acquitted a child involved in the home invasion that killed his wife. Justice Michael Copley found the teen not guilty of murder and manslaughter, instead finding him guilty of burglary and assault. We're really confused by this. And a lot of people were, angry and confused, though. We need an expert legal mind, I think, to give us a bit more knowledge and understanding to help us navigate and negotiate this verdict. And we've got one on the line. Professor Terry Goldsworthy from Bond Uni joins us. Good morning, Terry.
Yeah, good morning.
I can imagine you would understand both sides of this. Firstly, the outrage has been huge on this one.
Yeah, it is. I mean, if you look at the context of the recent election and the focal point of crime and youth crime in particular, that this has come so soon after the election, I guess just highlights why crime was one of the top 2 or 3 issues that decided that election.
How can a verdict like this be dropped? It seems to be out of step with community and public expectations. So can you talk us through how the judge got to this verdict? Did the prosecutor just not prosecute the case properly and strongly enough?
No, look, I think the prosecution, by the sounds of it, I mean, I wasn't in court, I didn't see the presentation of evidence, but from the reports I've seen, it seems the prosecution case was quite reasonable. I'm actually reading through the judgment as we speak, trying to see exactly what the prosecution alleged in detail. But I guess firstly for your listeners is why was it a no jury trial? And, in Queensland we allow judge-only trials where there's issues such as significant pre-trial publicity that may affect jury deliberations. So for your listeners, that's why it was heard by a judge only in over a period of 3 days. Now, in terms of the prosecution, it seems that it has turned on the prosecution of an unlawful purpose are committed in common. So you're talking about 2 offenders entering into a house, and that's what they call a common purpose. Mm-hmm. The issue that arose was knowledge of the knife, to make it in simple terms. So for the murder to succeed, it had to be shown that that the common purpose was entering into the house whilst armed to commit a break and enter, in simple layman terms. Then there's a probable consequence that if you do that and you're armed, that someone may be stabbed. Where the prosecution had difficulty is in convincing the judge that the common prosecution, the common intention was to go into the house armed, and they couldn't show that. The judge said, I can accept that there was a common intention in terms of breaking into the house. I don't accept that there's, evidence to show me there's a common intention to break into the house whilst armed. So once you have that issue, that the judge said...
Should they have been able to prosecute that successfully?
Well, they presented evidence of CCTV that was available from the house, etc. There's a timeline. Investigators have gone back, as you do in these things, looking at the preceding hours before the offence to see the interaction between the 2 offenders, etc. Now, that evidence was presented. The judge viewed that evidence, and he came to the conclusion that that they had formed a common intention to steal property from within the house, but he was not satisfied beyond a reasonable doubt that there was an intention common to both of them to do so whilst armed with the knife. And that is a crucial part. Now, the CCTV footage was infrared footage. The reports are that there was a momentary stop outside the front door where the second offender, who, from the reading of the evidence, was behind the first offender. The first offender turned around, looked back, and the other offender had the knife in view. Now, the issue was the judge was not satisfied beyond a reasonable doubt that there was sufficient light, etc., to enable the accused to see the knife. So on the basis of that, then, it's not a probable consequence. There's no common purpose in terms of entering the house armed, and the murder charge fails.
Gee, that seems flimsy, just as a layman. And Lee Lovell's mentioned this as well.
Yeah, look, I mean, it's a hard concept to get around. I mean, I've spent a number of hours kind of going through it this morning to get my head around what was the legal arguments, etc. Because we do have the section in the criminal code for murder, which says that, you're guilty of murder if, you conduct the death is caused by means of an act done in the prosecution of unlawful purpose, which act is such nature to like to endanger human life. So my thinking was, well, you go into a house armed with a knife, it's fairly straightforward. Intention doesn't apply. That's ruled out. There you go. You commit a break-in and, you're guilty of murder. It's much more complex than that, and that's the issue. I guess the LNP or the Attorney General will look at this decision and go, well, is there something we need to change if this is not in line with community expectations? I mean, the judge has made a ruling on the evidence he saw. That's entirely reasonable. But is this a circumstance where perhaps the government will say, well, there's a problem here that you can go into someone's house at 1 o'clock, 2 o'clock in the morning, whenever, and because you don't know your mate's got a knife and someone's killed, you're not held responsible. That'll be a question for the Attorney General to look at and see if they think there's something that needs to be adjusted in terms of the criminal law and how it applies.
Yeah, I've got a couple of questions I'll fire into you here. One's from, firstly, Lindy Atkinson from the Voice for Victims saying, being present at Judge Copley's judgment yesterday, it was sad to see Lee and Scarlett's look of sadness and disbelief. We all saw the same CCTV footage, which you're referring to there, Terry. The prosecutor, in my opinion, lacked the confidence of his convictions. This accused walks free on December 4 at sentencing to lead his best life, a travesty for Emma's family who appear to have no voice. I guess that's getting back to the debate over the footage. Did he see it or not? Was the light sufficient?
Well, I mean, I guess the interesting thing would be to have that footage released to the public so we can all have a look at it for ourselves. I haven't seen it myself. But I'd be very interested to see it because it seems to be the key bit of evidence that this whole case has turned on. In regards to the sentencing, I mean, if you look at Queensland sentencing data for aggravated burglary, which is what this is because it was committed in company at night, put aside the going armed part. For youth offenders, I don't hold much hope because, out of 500 odd offenders, only 13% got a custodial sentence, and the average sentence was 8 months. So that's 5 years' worth of data straight off the Queensland Sentencing Council website. So, it makes a mockery of these, and I've said it a number of times, of increasing the maximum sentence. The maximum sentence for aggravated burglary is life. But it is totally irrelevant to what we're seeing happening in the real life. This particular person has been in custody for 2 years. I don't want to preempt what the judge's sentencing is going to be, but I guess if you look at the historical data saying that average of 7 month imprisonment, those who get prison, people can work out for themselves. So, this is where I've raised the issue of minimum mandatory sentencing for serious repeat offenders so that, they do some time in custody for these offences. If we think it's not in accord with community expectations, then we need to get the government to do something about it. The other interesting aspect of this is that the first offender who pleaded guilty to murder and got sentenced to 14 years is appealing that sentence, which is, his right. Under those new laws to come in, which we heard derided long and hard by many people, adult time, adult crime, this is one of those cases where that change of law will make a difference. It won't in this case, but in future cases, it'll mean that youth offender will get sentenced to life.
I've got a question here from Ben Cannon, also founder of Voice for Victims. He says, can you please ask Terry, what are the weight items a judge must use in a trial and sentencing that are in favour of the criminal and the victims, and how are these used when appeals are lodged?
Yeah, look, I mean, in terms of victims, they will be able to give victim impact statements, and the survivors of a victim in a murder case can do that, so they can put in how it's affected them mentally, emotionally, financially, kind of impacts it's had, how their lives have changed. In terms of the offender, the things they look at are prior offending, antecedents, time in remand. As I've mentioned, this person's been in remand for 2 years. Prospects of rehabilitation, things like that. So they will all be weighed up. There'll be a pre-sentence report done, I'd imagine, that would be submitted to the judge to consider as to what perhaps the best options would be. And he will take all of those competing issues into into consideration. Now, when you appeal, all of that information would go forward to the appeal court to see what the judge had before him in terms of making that decision and whether that information supports the decision made. So there'll be a variety of inputs into the sentencing function that the judge will undertake. And I guess we just wait and see what happens. I mean, anyone can go to the Queensland Sentencing Council website and pull up these offences. They've got a great data dashboard there now, and you can see adult offenders, children, youth offenders, and you can see 5 years' worth of data as to what happens to them, what sentences are given, how long, and all those type of things, and whether the offences, the cases are increasing, decreasing. So, I'd encourage people go there, have a look there and inform yourself as to what the state of the justice system is.
What's your personal thought on the outcome of this?
Well, personally, I take the viewpoint if someone broke into my house at 2 o'clock in the morning and someone in my family was killed, I would expect both offenders to be held accountable.
Yep.
Now, clearly the state of law has said that's not what is going to happen. So, and that's what I was alluding to before. Do we need to look at changing the state of law? If you want to go into someone's house at 2 o'clock in the morning with your mate and, you then rely on the fact, I didn't know my friend was armed, I just think that's, that's a luxury that perhaps we shouldn't be accommodating.
You roll the dice. You went there with him anyway, and bad luck. He did have a knife. Yeah.
Well, that's right. I mean, I think we need to make a decision as a society. Are we prepared to let people get away with, using relevant aspects of the law to avoid being held accountable and being found not guilty, or do we want to perhaps tighten aspects of the law and say, well, no, we're going to take a different viewpoint, a more strict viewpoint, and you will be held accountable. So think about it next time before you break into someone's house at 2 o'clock in the morning. Yeah.
One final one before we let you go. I don't know whether this will force a rethink or rejig on what they're going to do with the laws they're going to put, the LNP government. But once they put tougher laws into legislation, how long will that take to get through the system, the judicial system, so it's available to judges to consider when they're doing sentencing? Could it take a long time?
Well, yeah, generally they're not retrospective of our criminal laws, so I would suspect that will be the case here. So any cases that have occurred before those legislative amendments enacted will be decided under the past regime, would be my understanding. Of course, the government may say, well, we're going to make it retrospective for the last 2 years or something. So, but generally that's not the case.
Okay, appreciate your time and your insights as always, Terry.
Thanks, Bill.
Professor Terry Goldsworthy, criminologist and expert on all this sort of stuff. Really good to learn and understand a little bit about how that process has worked. If you've got anything you want to add to it, you're most free to call the